Hi, I'm Mike Matray, your host of Healthcare Matters, where the medical and legal communities come together to discuss healthcare matters. Today's guest is Whit Johnson. Whit is a shareholder with CURRIE, Johnson, Griffin Myers in Jackson, Mississippi. Welcome to the program, Whit.
Thanks. Glad to be here.
An EMR's audit log and access log can be an Achilles heel when defending a medical malpractice claim. Can you explain the audit access log to our viewers, how plaintiff's counsel can exploit it, and how a healthcare professional can avoid these specific pitfalls when using an electronic medical record?
Well, first off, let me say I'm not sure you can ever avoid them, and I suspect most of the doctors out there have children, and I suspect that most of those children are on social media. And I can guarantee you, every one of those doctors has sat down and told their child, "Do not post something on the internet that you don't want everybody to see, and you don't, and that you won't, and that you might be ashamed of 20 years later, because once it's on the internet, it's there forever." Well, let me tell you, once it's on a computer, it's there forever too. And it is not only there, it is there as to when it got there, it is there as to what changes have been made, it is there as to who put it there. Every piece of information that has anything to do with that information is on the computer. That's why they call it metadata. Meta essentially meaning everything. It is information about information. And the only way to avoid the pitfalls is, it gets back to the first question you asked about EMR and best practices. You got to put your stuff in on time, and you've got to put it in accurate, because if you don't and you try to change it, the plaintiff's lawyers will know who changed it, they will know when it was changed, and they will know what it was before you changed it. There was actually a study up out of, I think it was out of Kansas. It's in the 2008 Journal of American College of Surgeons, and that was where they studied all of the different times that various specialties got into the radiological studies, and they were able to determine by type of doctor, because they knew everybody's passwords. They were able to determine what specialty looked at the radiology films themselves most often. When they looked at them, they even ended up saying there's a big drop-off at the end of the week regarding the number of times the scans are viewed, so that they were able to show that everybody's focused early in the week, but come Friday, nobody cares.
Excellent. Well, Whit, thank you for joining us today on Healthcare Matters, and I hope to talk to you again soon.
Sounds good. I hope this helped.
Thank you. In your defense of medical liability claims, what have been the most common errors and liabilities in a physician's use of electronic medical records? How do you advise your physician clients on avoiding those errors and liabilities?